Hi there, I'm Gregory Geffen,
And I am Benjamin Werber.
and we are the Geffen-Werber Law Group.
Along with our title company, Signature Title, we are for more than 2 decades your Florida real estate and title closing attorneys.
This is our video series where we break down some of the hottest topics and frequently asked questions to tell you what you need to know. Let's face it, nobody likes to see a deal cancel.
As the agent, you've already spent time showing the property, negotiating the offer, and putting the contract together.
The buyers probably spend time and money on inspections and perhaps an appraisal, only to realize that the property's not the right fit for them or that it didn't appraise.
Or perhaps the seller, with the contract in hand, has begun to make preparations or line up other commitments.
Never fun, but nonetheless, these matters are for the most part handled routinely and uneventfully, where the agents circulate a standard form for mutual cancellation and release, and then it's presented to the escrow agent, who will work with your buyer to either return the funds or perhaps hold them to apply to another offer.
However, we have found that there are several myths or misunderstandings about this process, particularly when it comes to our role, not as your attorney or title company, but as a designated escrow agent.
So let's take a few minutes, set the record straight, and tell you what you need to know.
Number 1, my buyer canceled just 3 days into a 10-day inspection. Why can't they get their escrow refunded today?
Well, this is very common, but what you must understand is that our role as escrow agent is different than that of your client's title company or attorney. We have a fiduciary obligation to hold the escrow monies and only disperse at the direction of both parties. We can't act as arbiter of the escrow, even though it's patently obvious, like here, that your buyer is entitled to a refund.
As the escrow agent, we usually require a fully executed release and cancellation or some other directive be signed by both parties.
Sometimes the seller might be unavailable or traveling when the cancellation comes through, and there's difficulty getting communication to authorize the release of funds. In these instances, patience is needed while we try to work with the listing agent to either get the release signed or some other acceptable directive.
We have a denial from the buyer's lender or condo board. Why do we still need a release?
Well, once again, like the first scenario, it might be clear as day that your client is entitled to their money back, but the seller has to be given some form of a due process and decide for themselves if there's any legal basis to impose a claim for the deposit, despite this denial letter.
If the seller refuses to return the buyer's deposit, can the buyer place a lien on the property?
We get asked this a lot, and frustrated buyers will often threaten filing a lien, but if the deal's canceled and the only issue is entitlement to the escrow, then the answer is unfortunately no. The only time the buyer may tie up the property is in connection with a specific performance action to enforce a contract to require the seller to close. Otherwise, filing a lien, known as a lis pendens, may result in a counterclaim for damages known as slander of title.
Number 4, the seller went to contract with another buyer, but still won't release my buyer's deposit. Is this legal?
So remember, cancellation of contract and entitlement to deposit are two separate items not dependent on one another. The fact that the seller went ahead and put the property back on the market, took another contract, and in some cases closed title doesn't automatically extinguish a claim from the seller to the buyer for the deposit for liquidated damages, particularly if the seller is claiming that the buyer somehow defaulted, which is why we require an executed release for every contract.
Number 5, the seller is giving us a hard time or is non-responsive about signing a release. What could we do?
Well, this tends to happen every so often and understandably can be very frustrating for a buyer. There's no one-size-fits-all answer to this issue. Naturally, we want to avoid a litigation situation because the costs could well eclipse the size of the escrow. Depending on the size of the escrow, we might do a workaround on a case-by-case basis.
On one deal, we may accept an email directive from the listing agent allowing us to disperse the escrow monies back to our buyer.
Other instances, we may send a registered letter to the seller advising that if we don't hear from them in a certain amount of time, we will assume they're not imposing a claim on the deposit and then we'll release it. Unfortunately, if the seller makes any type of affirmative demand on the deposit, then all bets are off. Even if we as the escrow agent can agree that they don't have a valid claim, your client may need to retain litigation counsel to start the process to resolve this. Once again, when a deal goes south, emotions could run high. Let's work together to keep everything and everybody on an even keel. In the meantime, I'm Greg Geffen.
And I'm Benjamin Werber.
And this has been What You Need to Know. We sure hope you enjoyed this video presentation. For more of these on a wide range of topics, please subscribe or visit our YouTube channel, visit our website, or find us on any of the various social media online.